you, Wayne, for your remarks, and thank you all for being here. You know, in 1953, Robert Menzies, speaking in the House of Representatives, then of course down the hill, said that the Crown is the symbol that wherever we are in the world, we are one people. And of course by that he meant one British people. And he said at the time, when it was proposed that the Queen's title should not refer to the United Kingdom, a change that was in fact made 20 years later by Gough Whitlam, he said it would be absurd to remove reference to the United Kingdom from the Queen's title, because, he said, the Queen sits on the throne not because of the laws of Australia, but because of the laws of the United Kingdom. And Sir Robert Menzies was dead right, constitutionally absolutely correct. The Queen is defined in our Constitution as meaning Queen Victoria and her heirs and successors in the sovereignty of the United Kingdom. So if Britain were to become a republic, the President of the United Kingdom would be our head of state. If Britain changes, as it's planning to, changes its laws of succession, then that will affect, by constitutional extension, the identity of our head of state. So, and it's important to remember that the reason the Queen is in our Constitution is because at the time Australia became a federation, we were not an independent country, not by any measure or means. The Queen in the Constitution can only be understood as meaning Her Majesty's government in Whitehall. And that is why there are still provisions. There's a provision in the Constitution, for example, that allows the Queen to annul any Australian law within 12 months of its enactment. It allows the Governor-General to refer a law to the Queen for her consideration. These were all standard provisions in colonial constitutions to enable the imperial government to oversight and oversee the government out in the colonies. And it is remarkable in many respects that Australia has become a thoroughly independent nation. In some respects we are more independent than the United Kingdom because we're not subject to the strictures of the European Union. But we've become a thoroughly independent nation without any changes to those provisions in our Constitution, without any changes to that text. But the question then arises, if the Crown was the symbol in Robert Menzies' days that we were one British people, what does it mean today, now that we are not by any... No one would seriously argue that Australia was a British nation or we were a British people. No one would say today, as Menzies said, and in these remarks he was echoed to the last syllable by his Labor opponents or Labor colleagues. Menzies said the boundaries of Britain do not lie on the Kentish coast, but at Invercargill, the bottom of New Zealand, and Cape York at the northernmost point of Australia. So it was a different world. The Crown, originally in our Constitution, symbolised the reality of being a subordinate part of the British Empire. It then evolved to symbolise, notwithstanding our independence, that we were nonetheless a British people, an independent British people. And that has changed. And so the symbol is no longer an Australian symbol. We can call the Queen of Australia, but she is not an Australian Queen. We can have debate about the titles and Australian honours and all of those things, but fundamentally it is an institution that is a foreign institution, a much beloved one, a much respected one, but nonetheless it is not Australian. And it's important to remember, and this is very important for Liberals to remember, that the founder of my party, of the Liberal Party, would never have used the arguments that are used in defence of the monarchy in Australia that are used today. He justified it clear-eyed and true that it was to symbolise the fact that we were a British people. That's how he rationalised it and justified it in the House of Representatives, and he spoke the truth then in a very clear-eyed way. Now, let me be honest with you about the prospects of reform, however. George Winterton used to describe Australia in constitutional terms as a frozen continent, and our constitution is terribly difficult to change, as I know from experience. I've extensive qualifications in not changing the constitution. And the problem, of course, is that you need a national majority and a majority in 4 out of 6 states, but above all, because we have compulsory voting, those people who do not understand the issue, who are not interested in it, do not seek to understand it for whatever reason, are much more inclined to vote no. And if you think about it, if you consider a change, someone proposes to you a change from the status quo and you don't understand what the implications of that change are, you're more likely to support the status quo. And so therein lies the big challenge that you have. Changing our constitution is terribly difficult. There have been no controversial changes to our constitution since 1946, and the one in 1946 wasn't that controversial, certainly not compared to the Republic. So it is very difficult. The pattern has been that the only changes that have been successful have been ones that either are essentially administrative, like those relating to senators, election of senators, or the retirement age of federal judges, or have had, like the Aboriginal referendum in the 60s, just overwhelming support. You've effectively got to have overwhelming support and very little opposition. So it's a big hurdle. Now, the challenge that we faced in the Republic referendum in '99 was, of course, very strong opposition from the monarchists, and they were entitled to make that case, and they made it forcefully. But most disappointingly, the argument put by the so-called direct electionists, who said the president should be chosen in a direct election by the people, and they didn't support the model that was proposed in the referendum. The challenge there, of course, was that they said, if you vote no now, you'll get another vote in 2 years' time. Remember that? Well, after the election was lost, they all vanished. I can't remember any of those direct elections lifting a finger to have another referendum. And that's why I said in '99, if you vote no, it means no for a very long time. Now, the easy solution is to say, well, we should have a direct election model. And this is the point that I address in my foreword to this book, because it's a critical one for us to be, again, to be very clear-eyed about. Had we gone for a direct election model in '99, we would, instead of having a large part of the Liberal Party and National Party supporting us, we would have had united opposition from the coalition. You wouldn't have had Andrew Robb or Peter Costello or Nick Greiner or John Fay supporting us as we did then. They would have all been on the no side. You would not have had distinguished constitutional lawyers from Zelman Cowen, Gerard Brennan and Anthony Mason saying you should vote for it. You would have had leading Labor figures like Paul Keating, like Bob Carr, saying you should not vote for direct election. In other words, direct election would have united the coalition against the proposition and divided the Labor Party, and you would have had many distinguished constitutional experts saying this is actually potentially produces a considerable degree of instability. So don't fall for the proposition that it would have been a slam dunk if you'd had direct election. I think it would have lost by an even bigger margin. The challenge, therefore, is to ensure that if we do go down a direct election route in the future, that people actually understand all of the implications of it. And, you know, it's certainly an option. In '93, George Winterton and I wrote a set of changes to the Constitution to codify the Governor-General's power, if the President's power, if he or she were to be directly elected. So it's feasible. It's complex, however. And that's why I've suggested that we should take advantage of the tools offered to us by the internet, which was not really available in the '90s, not to the extent it is today, to have a genuinely interactive plebiscite where you can engage people, explain the issue briefly, and then ask their opinion. Provide plenty of links to further material. In other words, use this as a massive, very cost-effective, I might say, massive constitutional educational process. And at the end of it, it'll be interesting to see what people's conclusions are. The experience we had in '99 was that whenever we had a focus group, and we had a huge one, you may remember, in Old Parliament House 2 weeks before the the referendum itself, a very public one, that if you polled people on the way in and said, how do you think the president should be chosen, most would say direct election. Within a few minutes of reflecting on it and reflecting that you're proposing to have a non-political, impartial, ceremonial, constitutional umpire sort of office chosen in a highly partisan manner, that support for direct election evaporates. And that was the experience with the big deliberative poll, as I said, 2 weeks before the election. So that's a sobering reality, which is why the process of engagement that brings you to the particular model you've got to put has to be one that is genuinely informing. It's got to be instructive so that people understand what the issues are and they understand what the risks are before they sign up to it. So I'm very positive about the Republican cause. As you know, I agree with Wayne Swan that it's always a good time to talk about our Constitution. And you know, people say, oh, we shouldn't be talking about our Constitution. That's ridiculous. Of course there are more immediate issues. We're not going to fight the election on this issue. This is not going to be what determines the fate of the Labor government. It's not going to be even on the radar screen. But we should always be alert to and interested in our Constitution. My point about the timing of a referendum is, I think, given all of the difficulties and challenges of winning a referendum, the prerequisites, it seems to me, are firstly to prepare the ground very, very well so that there is a strong consensus in favour of a particular model and people understand its implications. And I've suggested a process for that in my foreword to the book. But secondly, you need to have the timing. There's got to be the sense that this is an issue of the hour, and it isn't an issue of the hour for determination, at least for most Australians today. There's no point having another referendum that's going to be lost. I think our best chance of having a referendum which could win would be after the end of the Queen's reign. Now, I hope I'm wrong about that, and someone can prove me wrong, but that's been my view since 1999, so I haven't seen anything to change that point of view. But this book is an important step along the way. It's important to get people thinking about it, and above all, I'd encourage the ARM to consider this process of engagement. I think the idea, you know, the cost of setting up a national interactive plebiscite is not high. It's quite modest, really. This is one of the great things about the digital world. And so this is something that the ARM might consider, making sure that it gets an appropriately balanced set of questions and invites people from the monarchist case or the direct election case or all sides to put in make their contribution. And then see how that goes, see how many people will engage in it. It may... one of the lessons we've learned out of the internet era is that people's natural craving for freedom will always lead them to supporting measures and applications and services that offer more choice. More choice always trumps less choice. More engagement always trumps less engagement. And we've now got the digital tools to enable us to do that. So I'm not suggesting we become a cyber republic, but I think that the cyber sphere offers us a real potential for engagement that was not available in years past. So thank you very much, and congratulations, as Wayne said, to the authors of the book. Thank you.